I got lucky. I got handed one that was already
Oh,
set.
well, that is, you're lucky, huh?
Find it.
Yeah, I got the agenda. I think I'm okay.
It's on the, it's actually labeled October.
Oh, okay. You go back to your agenda page. Back to my agenda page.
Yeah, you get to everything from your agenda page.
Like,
Excellent, thank you.
I was trying to figure out if there should have been a second. And I guess a motion
I don't
to
think for the
adjourn
motion for
is
the
always
adjourn,
in
yeah.
order.
Yeah, I think it's always just the motion, isn't it?
get motion, but I did have my eyes on. I couldn't read.
Well, I guess even did, but we don't usually second it, do we? We usually have a second to adjourn.
Approve the minutes. Yeah.
To approve the
Second.
minutes we do,
Yeah.
yeah, but not to adjourn the meeting. Yeah, okay, yeah, that's what John was asking. I said, I don't think we don't do. No. Motion can come out of there.
The name of. First, we're out of here.
You guys ready?
At this time, we'll call the November 20th, 2023 meeting of the East Hempfield Township Zoning Hearing Board to order. Members of the board who are present this evening are Mr. Luce, Mr. Kyle, Mr. Bingham, and Mr. Herr is present via Zoom, and myself, Mark Hanson, Vice Chairman to the board. Also for the record, we have Ms. Graham, Zoning Officer to the Township, and our legal counsel, Attorney Jason Hess as well. We also have a court reporter with us. Scheduled this evening are 4 new cases and any old business that may come before us this evening. The board will hear each case in an informal matter without strict compliance with the rules and procedures used in a court trial. We ask each applicant and any individual interested in a case to step in front of our table and explain the circumstances involved in their application. Applicants may present their case themselves through their attorneys or any other representatives. My fellow board members and I, as well as our solicitor, may ask the applicants questions from time to time during the applicant's presentation or at its conclusion. All persons having an interest in the application will be given the opportunity to ask questions of the applicant, offer evidence of their own, and inform the board of their position on the matter. In the interest of prompt and orderly disposition of each case, however, we ask that interested people refrain from speaking until the applicant's presentation has been completed and the board has had the opportunity to question the applicant. At the beginning of each case, people who are interested in the case should decide whether they desire to be a party to it. By giving the status of a party, that person will be entitled to receive notice of the decision in the case and be entitled to participate in any subsequent appeal or rehearing. Individuals who are not given party status may nevertheless ask questions or present evidence, but will not receive notices of the decision or will not automatically be entitled to participate in any appeal or subsequent rehearing. If you desire to be a party, we will ask that you sign an entry of appearance form at the appropriate time. Although each party will receive a written copy of the decision, the mechanics of typing and signing the decision will take approximately 4 weeks. We ask that each person who asks a question or makes a statement first state his or her name and address for the court reporter. Lastly, in the interest of time, I will minister the oath of or affirmation to all applicants and to everyone and anyone who anticipates making any statement with respect to any of the hearings this evening. At this time, would you all please rise? Under penalties of perjury, you swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth. If so, please say I do. Please remain standing. We'll salute the flag. I pledge allegiance to the flag of the United States of America, to the republic which stands, one nation, under God, indivisible, liberty and justice. Again, just to let everybody know, this meeting is also taking place on Zoom. Beth, have the cases this evening been posted and advertised in accordance with the sunshine law and the ordinance?
They have been.
Gentlemen, you have received a copy of the September 18th, 2023 board minutes as presented by our secretary. If there are no deletions, additions, or corrections, I ask for a motion to approve the board minutes as submitted.
So moved.
That would be several, so moved.
I'll second.
Okay, motion by Mr. Hur, seconded by Mr. Luce. Mr. Luce,
In favor?
Mr. Kyle,
In favor.
Mr. Bingham,
In favor.
Mr. Hur,
In favor.
and I will also vote in favor. The minutes have been approved 5-0. Beth, any old business?
There is none.
Beth, will you call the first new case, please?
Case number 2468, Michael Walburn, 1213 Woodworth Drive, seeking a variance to front yard setback.
Good evening. Requesting a variance.
Excuse me, state your name and address for the court reporter, please.
Michael Walborn, 1213 Woodworth Drive.
Okay. Go ahead.
Requesting a variance for the minimum setback. My property is a corner lot, so I have 2 front yards. The deck patio pool that I'm trying to put in would be encroaching on the front yards, going on the back of my house, which would be the Cutler Circle you can see in the map drawn there. I think we're going over around under 8 feet into the 35-foot setback. I do have 2 letters provided to me recently from 2 neighbors in support of it. Not able to put the stairs on the other side because then I would be encroaching on the neighbors or on the 5 feet on the side yard in the neighbor's property line. Not able to angle the pool in any way because then we're reaching the back side, which would encroach on the other neighbor's property line.
Mark, this is Elam.
Yes.
Would you have the applicant speak into the microphone,
Sorry.
please?
You can
Sorry.
adjust that or take it out of there and hold it up to your,
Can you hear me clearly now?
that's better.
Okay. Start over or?
No, that's fine. You said you had 2 letters from neighbors.
Yes.
Did you want to enter them as an exhibit?
Yes.
Earl, as soon as you're done with them, can we see those, please? While she's working on that, Mr. Walburn, you have anything else to add?
No.
Any questions?
I'm just non.
Are you going to be putting a fence around this, which I'm assuming under
Yes.
ordinance you have to?
Yes.
How high is your fence?
I don't know, but going to be to code. Part of the Keystone Custom Decks who's working with me, the project. They're the ones that are going to be installing that fence.
I'm sorry, I lost you again. If you
Sorry, Keystone Custom Decks, who's doing this project, they're gonna be the ones installing the fence, but it would be to code.
Because your fence, especially in that front yard on the side street there, can only go to 4 feet high. You know that, correct?
Not aware of that, sorry.
Is there a height requirement on fences for pools?
That would be a code question.
Nate, do you know that answer?
I do not know.
I'm thinking it's 4
It's
feet,
gotta be 4
actually.
feet.
It's gotta be at least 4 feet.
It's at least 4 feet.
Yeah.
Yeah.
So as long as you don't exceed that 4-foot height, you'll be all right.
I wasn't planning to, no.
Okay. With the pool put in the deck and the patio around the pool. You know what your lot coverage is gonna be?
I do know that we would need a stormwater management. That's going to be then our next part of the application process is to have that looked at and reviewed. I believe that they're within those, I think when I spoke last to Keystone Custom Decks, they mentioned about a seepage pit needing to be put in.
Your maximum lot coverage in this particular zone is only 35%.
They're
Okay,
under, yeah,
okay.
they're good with lot coverage. They will have to do a stormwater
Okay.
infiltration, but lot coverage was okay.
All right. And any other, Mr. Hurd, any questions?
No,
Beth?
Nope.
Jason?
Yeah, first, I'm not sure, did you ask if any other people wish to be a party
No,
to
I
this
forgot to do
proceeding?
Anybody in my audience want to be a part of this case?
On Zoom.
I'm good.
Okay. Sir, you mentioned that you mentioned something about 35-foot setback. Are you referring to the front yard setback?
Yeah,
That's 30 feet, the front,
Is
30 feet in the front.
30 feet.
30 feet,
I was gonna
okay.
say.
sorry.
but that's, I mean, I guess the real issue is that it's actually, you're not allowed to have any accessory structure in the front yard, correct? Okay. And so you would be, how close is the closest point to the, right away?
27.2 for the edge of the stairs to where it would be the closest. Yeah, the red line there to the left.
Okay, so it's actually the sort of the curvature of that cul-de-sac that causes it to.
Yeah, it curves into my property and then also at the end of the cul-de-sac, it gets bigger. So therefore,
Okay,
I should say the street gets wider.
okay, that's all I had, thank you.
Any questions from anybody in the audience?
Mark, this is Elam again.
Yes, sir.
The request for the variance is being for the, in the front yard.
Right.
And if I'm right, it's only 2.8 feet.
Is it 30 or 35?
It's a,
You can't have an accessory structure in the front yard.
Right.
In the low density residential, it's 30 feet.
it's actually 7.8 feet. Right?
He's encroaching
He's
seven,
encroaching in,
correct,
right. So
Yeah.
it's a 7.8 foot
Encroachment.
encroachment.
encroachment, right.
Well, that would be if it was 35 feet, but it's 30, so it's
So
2
it's
point
2
something
point-
feet. But
2.8.
Gotcha.
yeah, but the real issue is you can't have any, the zoning ordinance doesn't allow any accessory structures in the front yard. So that would be what the variance is from.
Right, we'd be giving a variance to encroach into the front yard by 2.8 feet.
Well, no, it would be a variance to allow a structure in the front yard because the variance doesn't allow any accessory structure in the front yard. So
We could condition that to 2.8 feet, correct? Because you can't go any
Right.
farther than 2.8.
Sure.
feet. Yes.
That's just- I don't understand how that works with the,
So you're only allowed.
but I understand, but Woodworth is his front yard. That's his address. I understand that. I do understand that, but I'm considering how do you consider with his front yard, with his backyard, if everything is a front yard, then
This
there's
is
no.
back. This is side,
Mhm.
front.
Right. I got that. I'm just saying, it's just confusing when this is his address.
Any other questions? Mr. Walburn, do you have anything else to add?
No, thank you.
All right, this time we will close testimony in case number 2468. And I will entertain a motion. Go ahead.
Mr. Chairman, Mr. Vice Chairman, in case 2468, for the property located at 1213 Woodworth Drive, I propose that we approve the variance section 270-3.5 E2 to allow for a 2.8-foot encroachment in the front yard from the allowable 30-foot. For a final 20, well, it wouldn't be 27. Yeah, for a final 27-foot encroachment.
And I'm just gonna clarify that because so if you look under E2, it says accessory. It says not permitted in front yard. So it would be actually the variance from a variance that says, from the provision that says there's no accessory structures in the front yard. Because it's not 30 for accessory
Allowing the
structures.
encroachment,
It's
we're allowing the.
right.
Okay, got it.
So then we can condition it that they can't encroach any more than 2.
Right, to allow, so you approve the variance of section 270-3.5 E2 to allow for the pool to be built in the front yard
Okay, and the
with the
condition,
condition that it should not exceed a 2.8-foot encroachment within the 30-foot allotment to allow for a final encroachment of 27 feet.
all right.
With the normal condition.
We have a motion,
Makes sense.
yes. For the application of Michael Walburn for property located at 1213 Woodward Drive, Lancaster, PA 17601. May have a motion to approve the variance to section 270-3.5 E2 to allow for a pool deck and pool into the front yard setback with the following conditions. It cannot encroach more than 2.8 feet into the setback, allowing for 27.2 feet setback from here on out. Is that your motion?
Yes.
Do I have a second?
Second.
You just been waiting to do this. You're gonna do that all night, aren't you?
I didn't give it to him anyway.
Never gets to say.
So we have a motion by Mr. Luce, second by Mr. Bingham. Any discussion, gentlemen? If not, how you vote? Mr. Luce,
In favor?
Mr. Kyle,
In favor?
Mr. Bingham,
In favor.
Mr. Herr,
In favor.
and I will also vote in favor. Your variance has been approved with the conditions.
Thank you.
Beth, next case.
Would be a pain.
Case number 2469, Winners Investments LLC, 1500 Wilson Avenue, seeking a use variance.
Good evening, board members. My name is Mike Grob. I'm an attorney for the applicant here this evening. I'm from the law firm of Nicholas and Honottle. And this is an application, as Beth indicated, for the property of 1500 Wilson Avenue for a use variance to permit a commercial HVAC business. And the property, although it is zoned low-density residential, has been historically used for commercial purposes. And the topography of the property, the layout, the improvements on it, all lend themselves to a commercial use as opposed to a residential use. So I have two witnesses to present here this evening to the board, and I do have some pre-marked exhibits that I'd like to present as well, if I can pass those out.
Okay.
Do you have any? Okay.
So my first witness, board members, is Mr. Kevin Wilson, who is the owner of the property, the current owner. So Kevin, you want to come forward?
While we're waiting for him, let me again ask this question. Does anybody in the audience wants to be a party to this case? All right, so go ahead.
My name's Kevin Wilson, 1500 Wilson Avenue, Lancaster.
And Kevin, you are the current owner of the property, is that correct?
Yes,
And you purchased the property in 2017, is that also correct?
yes.
Kevin, I want to show you what I have pre-marked as board exhibits 1 and 2. So I'm going to refer to those briefly, board members. So Kevin, I'm going to show you a plan that's dated 1995 that depicts the property. So if you can take a look at this, not what's up on the screen, actually down here, no problem. Yep. So this is a plan from 1995 for the proposed development of the property at that time. Is that your understanding?
Yes,
And that's a 2-page plan, correct?
yes,
And the first page is just a cover page, and the second page actually shows the layout of the property in terms of the proposed improvements at that time. Is that your understanding?
yes,
But that also actually reflects the actual improvements that are on the property at this time. Is that also correct?
yes,
Okay. And then applicant's exhibit 2 is what is on the screen before the zoning hearing board, Kevin, and that's a copy of the Lancaster County GIS map of the property. Is that correct?
yes,
And again, that shows the property as it currently exists and is improved. Is that also correct?
yes,
So let's talk a little bit about the property itself, Kevin, before we talk about your acquisition of it. The property consists of one building, one structure, right?
correct.
And then there's a large parking area on the Lancaster County GIS as we're looking at it to the right of the property and then also to the left. Is that correct?
Yes,
And the parking area to the left looks like it has a driveway connection to the commercial use that
Excuse me, I
fronts
wanna-
onto,
Let me interrupt you for a second. You have a pointer for him?
Here, right here.
If you would use this Please.
There's one right there.
and point to that screen.
You're gonna kill us.
which
if
screen would you like me to point?
That
That
one right
one.
there. Easier as you're talking about it, pointing.
The green button. There's like a green bar.
There's one at the very top.
Yeah.
Technology.
Lost it.
Is it on?
No. Yeah, this one more Japanese.
There we go.
Highlighted yourself.
Okay, so Kevin, again, as we look at the property, I have the green pointer on the structure, correct?
yes,
And then just to the right of that is a large parking area. Is that also correct?
yes,
And then also to the left is an additional parking area.
yes, yes,
And the parking area that I have the green pointer on now has a driveway connection to the commercial property that is located along Columbia Avenue. Is that correct?
yes,
And is that parking area currently used by that commercial business?
yes,
And that's a Kentucky Fried Chicken?
yes,
But it is part, that parking area is part of this property.
yes,
Okay, thank you. So Kevin, let's talk a little bit about your acquisition of the property. You indicated that you acquired the property in 2017. Is that correct?
yes,
And at the time you acquired the property, was it your understanding, based on the agreement of sale that the seller had presented to you, that the property was zoned commercial?
yes,
And there is, board members, in your exhibit packet, a copy of the agreement of sale for Kevin and Terry Wilson dated 2017. That's exhibit number 4. And if you look at that in the zoning classification section of the agreement of sale, it indicates that it was zoned commercial, or at least the seller believed it was zoned commercial at that time. So Kevin, when you purchased the property, what was the use at that time by the then owner?
The downstairs was a sub fundraising business. Made for schools, made subs and pretzel sandwiches and sold to schools and scouts and churches, sports teams. And the upstairs, there was a tenant.
So when you say a tenant, the upstairs was used for residential purposes.
Correct.
And as part of the agreement of sale, you were presented with a copy of the lease for that tenant that used the second floor. Is that correct?
Yes.
Okay, and board members, there's a copy of that lease agreement that's exhibit number 5 in the exhibit packet that you have. And that residential lease agreement was dated 2009. Is that correct?
I think so.
So if I showed you that it's dated 2009, would that be your understanding?
Yes.
Okay. So your understanding was, at least since 2009, the second floor had been used for residential tenant purposes and the first floor used for the commercial business purpose.
Yes.
Now, as part of your purchase of this property, did you also purchase the Boaz fundraising business?
It was a separate, yeah, we also bought the business.
And once you purchased the property, did you continue to utilize the property for that fundraising business?
Yes.
And again, can you describe for the board just briefly the nature of that business? How did it operate from this property?
We would just make subs, pretzel sandwiches, and then I would deliver them to all the schools around here. The Hempfield High School, Solanco, Penn Manor. And that's what we made the sandwiches almost every day. Like,
And again, to various organizations for fundraising purposes.
correct.
Yeah. So on the first floor, in terms of the commercial use, you had some sort of prep kitchen, but not a full-blown commercial kitchen.
Correct. It was just cold sandwiches being made. Cold cuts, meats and cheeses put on a roll. There's no stoves. There was a cooler, a big refrigerator to keep the stuff in.
But you clearly bought the property for the intended commercial use on the first floor.
Oh, yeah. Yeah, because that's where the business was. We bought the property and the business.
So at some point, the tenant on the second floor moved out of the property. Is that correct?
Correct.
And then at that point, you simply converted the second floor to your residence.
Yes.
Okay, you currently reside there as well.
Correct.
Kevin, I'm going to show you what is marked as Exhibit 3, which is the East Hempfield Township zoning map, or a portion of the East Hempfield Township zoning map. And Kevin, you'll see that on the right-hand side of Exhibit 3, there is a yellow shaded area which represents the low-density residential zoning district. Is that your understanding?
Sure.
And then.
Yes.
Yes, and this property, that's the subject property here tonight, is located in that residential district. Is that your understanding?
Yes.
Okay. But you'll see that there's been a highlighted in blue outline on that yellow shaded area. Does that represent your property?
Yes.
Again, which is on the corner of Wilson Avenue and Conestoga Boulevard.
Yes.
So the zoning district immediately adjacent to your property, which would be to the south. And I'll use the pointer again if we refer back to the GIS map. So the property located immediately to the south where the Kentucky Fried Chicken is, and the property immediately to the east of that, which is the Turkey Hill, those are located in the CBC zoning district. Is that your understanding as well?
Yes.
And that's all commercial uses. Is that correct?
Yes.
In your opinion, is your property better suited for a commercial use as opposed to a residential use in the low-density residential zoning district?
Yes, I think it's
And-
commercial.
And why is that? Just because of the improvements on it?
It's the Turkey Hills beside it, the KFC's right to the south of the property, straight across east is a garden center, that's commercial. And the building across Wilson Avenue to the north is an apartment building. And then the big lot there behind the apartment building, is tennis courts and a parking lot for the guys that come and play tennis. And that's all their grass area to the west of where he has the green.
And then, Kevin, if we look to the east of your property, there is an open lot that is also in the low-density residential zoning district. Is that correct?
Yes,
But that's currently unimproved. There's no residence located on that. Is that correct?
correct.
That's just for the record, that's to the west.
I'm sorry, that's to the west. Yes. Thank you. Okay, thank you, Kevin. That's all I have for this witness board members, unless the board has any questions for
Gentlemen, you have
Kevin.
any questions for Mr. Wilson?
I have one question.
Go ahead, Mr. Bingham.
Is the parking lot that is on, I guess, what would be my left looking at that picture, shared with the Kentucky Fried Chicken? They don't appear to have enough parking to handle their business unless they use your parking.
Yes, they use that parking lot.
So you have an agreement with them?
Yes, they
on that?
lease that parking lot.
Okay. So in fact, part of the commercial district is actually using your parking, even though you're not.
Correct.
That's correct, yes.
And that was
Thank you.
before we ever had it.
Now, Kevin, just along those lines, as a practical matter, even though KFC leases that parking area, is it often used, or is there only a few spaces that actually get used for overflow parking?
They don't use it much. That usually a couple of their workers park in it, or, yeah,
But
Yeah.
technically, it is leased to them and used for that commercial purpose.
yes,
Mr. Bingham, just for the record, that parking lot lease was, I believe, part of case 568 in the decisions that were sent out today, I believe.
Okay.
Mr. Wilson, how long is that lease for with KFC?
with KFC, to 2027,
2027.
I believe, yes. Like they renewed it. And then they stopped when COVID came. They didn't
Okay.
want it, and then they renewed it.
And the only entrance to that parking area is through KFC, correct?
Correct.
Jason, do you have any questions?
Yeah, I do have a few. Thank you. Mr. Wilson, was there a lease with the fast food restaurant, with KFC, I guess, prior to you entering into the lease?
Yes. So
Okay.
when we bought it, there was a lease and they just continued it with us.
Okay. So were you aware of the decision, there was a decision in it's like 1995, case number 1005, and maybe this is a question for your attorney, but if there had been prior decisions for this.
Yeah, we can address that. So Kevin, when you purchased the property, your understanding again, as you testified, was that it was zoned commercial for commercial use.
Yes,
And as far as you knew, that use was permitted and that any prior zoning approvals from the township allowed that use at that location, correct?
yes, because they already had the lease and so they just transferred to us.
And so you first became aware that there was some incongruity between that understanding and what the actual township records indicated when you recently listed the property for sale and prospective buyers contacted the township to confirm the zoning. Is that correct?
Yes,
So until that time, you believe that the property and your operations were in full compliance with the zoning ordinance?
yes, and we also thought it was because when KFC stopped, like around COVID, we came out here and talked after COVID was over, just as this gentleman said, I don't have my reader on the end. You said it doesn't look like they have enough parking. So we were told they had to use that parking. So we came out and asked, don't they have to use that? Because we wanted the lease. You know, so yes, we thought it was okay to use it as commercial.
Does that help clarify?
Yeah, and I'm confused by one of the conditions from that decision because it says condition 5, it mentions landscaping and or barriers shall be provided such that access from one property to another is restricted. And I mean, it's hard to tell from that condition that it could be interpreted that there's that driveway from the one property to the other should be closed off, but to your knowledge, has that ever happened?
No, and I guess my understanding, Mr. Hess, is I think that the closing of that access is actually from this part of the property over to the parking lot that's being used by KFC, so that there wouldn't be any continual, I guess, access from here over to the KFC used parking lot and then out to Columbia Avenue, was my interpretation of that.
Okay.
Because I think the KFC approval for use of that parking area predated the 1995 decision. I think the oldest decision on the property that the board has before it was the decision to authorize the KFC use of that parking area.
You're saying that was the most recent?
No, that was the
Oh, that was
oldest.
the
Yeah,
oldest,
that's
okay.
the oldest decision, I believe.
That's the oldest positive decision. There was a case number 9 that was denied by the board, which was in your submittal.
Yeah, and I think there was at least, one application prior to the 1995 decision that was denied. But I think the earliest one, and Beth, you can correct me if I'm wrong, was the KFC decision.
So in 1965, that was case 9, correct?
Oh, okay, so that was,
Case 9 in 1965.
that's the oldest, okay.
Yeah.
Well, in any event, the KFC decision authorizing the use of this area of this property predates the 1995 decision.
Let me ask a question here. There are basically 4 cases pertaining to this property that were approved one way or the other by this board. 568, 738, 991, and 1005. If the board was to grant your request tonight, all the conditions would still be in play on those 4 decisions. Unless your variance request were to override one of those decisions, one of those conditions, but all those conditions would remain in effect. Is that okay?
That would be our understanding, again, to the extent that any of those conditions aren't inconsistent with the new proposed use of the property.
Correct. Anything else, Jason?
One second. And the use that you're proposing doesn't require any changes to the structure. I don't know if that's your next witness, but
Yeah, and we were going to address that with the
Okay.
next witness, but no, there's no change to the footprint, no change to the impervious surface, no increase in the parking area, no changes at all proposed.
okay, thank you.
All right, Kevin, thank
So
you.
basically, the only change is gonna be made on the interior and the use.
Correct.
Beth, do you have any questions?
I don't.
Anybody in the audience have any questions for this witness? All right, your next witness.
Thank you. My next witness is Mr. Michael Winters.
Mel Winter, 1500 Wilson Avenue.
I'm sorry, can you say that again?
Mel Winter, 1500 Wilson Avenue.
So your current business address, though, is not 1500 Wilson Avenue, correct? So what's your current business address?
It's 1007 Nisley Road.
And you've been sworn already, Melvin. What's the nature of your business?
It's residential heating and air conditioning,
And how long have you been in business?
8 years.
How does your business operate in terms of its daily operations?
So for currently how we do it, we buy equipment, we hold it at our current facility. Guys come in the morning, we load up and we go about, whether it's in Lancaster, York, Harrisburg, and we do residential where it's installing, servicing, in the residential community.
And you currently have an agreement of sale with the Wilsons for purchase of the property, is that correct?
That is correct.
Um, and you indicated you've operated your current business for approximately 8 years.
That is correct.
Can you describe for the board how you would use the subject property in connection with your business?
Yeah, so the bottom portion is a warehouse. It'd be used to store our heating and air conditioning equipment. The guys would meet up, they would load up their vehicles and go out throughout their day. And then at the end of the day, they would park those vehicles and go home. The upstairs would be used for office space.
So it's largely headquartering of the equipment and materials. Your employees get there in the morning, they load up, they go out to the various designated HVAC jobs, return in the evening.
That is correct.
And how many employees would you have at this location?
7,
And what would the hours of operation be?
8:30 to 4:30.
And that's Monday through Friday?
That is correct.
How about Saturdays? Is there any time that you guys work Saturdays, like in the summer or?
In the summers, we do work Saturdays if it's extreme. It's normally from 8:30 to 12:30. It's not a full day.
And usually only in the summertime?
That's correct.
Are you proposing any outdoor storage of materials?
No,
You do have a trailer, though, that you use for transporting some materials, is that correct?
that is correct.
And that would be located on the property as well?
It would be.
And is that a 7-foot by 14-foot trailer?
That is correct.
By what means are the materials that you receive at the property delivered there? Do you have tractor trailers come in, or do you have box trucks? What kind of things deliver
They're
those?
normally about 28-foot box trucks. So the suppliers are local. They come in the morning and they drop off. That equipment would come into the warehouse. And then as the guys would pick off from those piles to the jobs, we would take them out and go about.
And how often does that happen? Is that a daily thing, or
Probably twice a week.
would there be any outdoor activities at all?
No outdoor activities.
So from your perspective, the proposed use wouldn't create any noise, dust, odor, fumes, anything like that, that would negatively impact the surrounding properties?
Correct.
Any nighttime activities?
Nighttime activities.
So based upon the number of employees and based upon the existing parking area, is there adequate parking for your proposed use?
Yes, there is.
And we did cover this a little bit, but you don't propose to expand the building, you don't propose to expand the parking area or any impervious surface, is that correct?
That's correct.
And would you say that this location and the layout of the property is very conducive to that commercial operation that you have? And do you believe that if you were permitted to operate the business at this location, that it wouldn't have generally any negative impact on either this property, the surrounding properties, or the zoning district in general?
Correct.
And you're asking for the minimum variance necessary to grant the relief so that you can use the property?
Yes.
Thank you. That's all I have for this witness, board members.
Gentlemen, any questions for the witness?
Mr. Winters, will you have any customers at that location?
We do not have customers come to the location.
And how many parking spaces are there right now existing?
I think there's currently 9.
So as you understand, there's 9 lined spaces, but there's actually probably room for more spaces in there that you could line and create additional spaces.
Correct.
But the existing spaces are sufficient for all of your employees at this location.
Yes.
Beth, any questions?
No.
Jason?
No.
Anybody in the audience have questions for this witness? Okay, thank you.
Thank you, board members. That's all we have in the way of testimony. We're happy to answer any questions you have. I do have an outline for the board just in the back of the exhibit package, just outlining the basis for our request for the use variance and the nature of the hardship. The hardship, of course, is based upon the unique nature of the property. When you look at this compared to other residentially zoned properties in the area, this is obviously very different. It's historically been used as a commercial property primarily, and the use really is appropriate for the property. So we'd ask the board to approve the request.
Okay, thank you.
Nice. One more question
Sure.
before Mr. Winters. I'm sorry, I should have asked this.
No worries.
before. signage that you have for the business.
Yes, sir.
Will you be putting a sign up outside? or-
Yes, there'll be a sign on the building and I think it's 4x8 is the code. And then there's also going to be one that's towards the front entrance there.
When you say front entrance, can you point exactly where?
It's 79.8, I believe.
Okay, so you're talking on Columbia Avenue, or
So where would that be? Where?
Going towards the road there.
Up in here?
right there?
Yes.
Okay,
Yes, sir.
all right, thank you. Sorry.
Thank you.
Okay, at this time, we'll conclude testimony in case number 2469. We'll take administrative notice of applicants' exhibits 1 through 7. And administrative notices of case number 9, 568, 738, 991, and 1005. Gentlemen, at this time, we'll entertain a motion for the request of the applicant.
You handle this one.
Okay. In order to make sure we have a vote, I'll go ahead and make a motion. Make a motion to grant a variance in case number 2469, the request of Mel Winters or Winters Investments LLC for property located at 1500 Wilson Avenue, Lancaster, PA 17601. Make a motion to grant them a variance from section 270-3.5B to allow for a commercial use in the residential zone, with the following conditions: that the business hours will stay as testified to Monday through Friday, and then the Saturday hours during the summer. And also that all existing conditions from previous cases will remain in effect unless overridden by the variance request tonight. Do I have a second?
Question.
And
Sure.
one thing to point out, that the board should take administrative notice of those decisions as well.
I did of those 5
Okay.
cases.
Would you amend your motion to include a restriction that the signage has to be placed on Conestoga Boulevard, not Wilson Avenue?
Yes. So we have 3 conditions. The conditions in the 5 cases be maintained. The sign has to be put on the building facing Conestoga Boulevard, and our standard conditions.
Second.
Second by Mr. Luce. Any discussion?
Mark,
Yes.
feel the only thing I want to make sure it's onto the record is the location of this property, although it's in a quote unquote residential district. Wilson Avenue sort of separates the true residents from commercial properties that are facing the Columbia Avenue and the lot in itself is probably not conducive to a residence. So, I think that's a justification for granting this variance.
Okay.
Thanks.
Anything else, gentlemen? If not, we'll take a vote. Mr. Luce?
In favor?
Mr. Kyle?
In favor.
Mr. Bingham?
In favor.
Mr. Herr?
In favor.
And I'll also vote in favor. Your variance request has been granted. Thank you,
Mark, can you tell me who seconded that motion?
Mr. Luce.
Mark, I have to go dark for a while, so.
Okay.
I'll let you know when I'm back.
Let me know when you're back. All right. Matthew, you want to call the next case, please?
Next case is number 2470, Eric Wardrop and Tasha Plunkett, 135 Root Road, seeking a modification of conditions.
Go ahead.
Thank you, Mr. Vice Chairman and members of the board. Good evening. My name is Matt Cream. Is Mike Grubb, also a partner in the law firm of Nicholas and Hohenadel. And I'm counsel for the applicant. With me this evening are both of the applicants, Eric Wardrobe here at the microphone, and Tasha Plunkett. Both have been sworn in case you have questions for either that we don't cover in our presentation. Members of the board, this is a request for the modification of a condition that was imposed in a decision by the zoning hearing board in 1996. A lot has changed since 1996, except the chairman of this board. Elam Herr was the chairman of the board in 1996 and remains the chairman of the board in 2023.
He actually goes way back farther than that, but go ahead.
Yeah, I'm aware. Yeah, I first appeared in front of this board in 1981. The application at that time was for the approval of what we commonly refer to as the quota of subdivision rights for single-family dwellings from an agriculture zoned property. As a consequence of approving those 3 subdivisions and 3 single-family dwellings, the board imposed a condition and directed that it be reflected in a plan note that no dwellings shall be erected and no additional residential lots shall be created from the 4th lot, which was designated as the remaining lands. And that with the creation of lots 1, 2, and 3, the quota of residential dwellings and residential lots are exhausted. We are not asking that be changed at all. We are not here asking that the condition be modified in any way to permit additional subdivisions and additional single-family dwellings on those subdivided lots. The request this evening is to permit a dwelling as an accessory structure and use to the proposed agricultural operation for the remaining lands which meet the definition of the township for a farm parcel. I'm going to have Mr. Wardrobe describe what is being proposed for the property.
Mr. Cream, before that, could you use the pointer and on that screen, point out the 3 properties that were separated and what's left of the original, please? Because it was very tough to make out on the submitted map.
Eric, can you do?
Okay.
Those are the 3 lots that were the subject of the 96 decision. If there was a previous subdivision that wasn't reflected in the 96 decision.
In the 96 decision, would you show me what is designated the remaining farmland?
Here, or going up and down.
So Eric, while you have the floor, please describe what you and Tasha are proposing if the board were to grant this approval.
So our plan for this property would be to construct a high-end riding facility with roughly 14 to 16 horse stalls. It would include a indoor ring, an ancillary building, and then the balance would be pastures. And this property fits size-wise for what we're looking for. My wife Tasha runs a hunter jumper business. She's been doing that for roughly 10 years. And we've been on the lookout for a property where we could build kind of our custom setup, but we need to have the ability to have a dwelling on the property just from a horse care standpoint. Today, we lease a barn, which is roughly 20+ minutes away from our house, and it makes it very difficult for her to kind of manage the horse care. So that would be the plan for this property.
So you would plan to move onto the property?
Yes,
And you say you are gonna build a barn?
yes.
Okay.
Yeah, we would have 14 to 16 stalls, give or take.
And Eric, as part of the application, you have a conceptual sketch plan that would show the barn and other horse operation buildings, as well as a farm dwelling.
Correct.
And all of that can be accommodated on this lot, meeting the definition of an agricultural operation, meeting all of the dimensional requirements for an ag operation on a farm parcel.
Yes, this is a very preliminary plan, but this size of property fits very well for the size of farm that we're looking to build.
You're showing two separate accesses.
Yeah, so this property has an easement. This property has an easement that comes right off of here, that was put in place, sometime in the 90s, I believe. So our plan would be to have access to a dwelling, a dwelling in this area here, utilizing this residential access, and then have a access over here for the farm, which is where we would, use for more of the commercial side of the farm.
And your sketch plan is showing only a modest connector.
Excuse me, Mr. Cream. Beth, could you put the sketch plan up there, please?
Give me a minute.
Mr. Cream will make it easier. That way you can point out.
Yep.
Are you talking the site plan, Mark? What is it that you're looking for?
This one,
This one.
Yeah, okay.
Up a little bit though. It shows mostly what we need. No, there you go.
Okay, so this is the easement that I referenced. So we would envision kind of our residential house access here. Again, this is preliminary plan, but we, would have kind of the house in this general area. Then we envision kind of the commercial access to the barn, trailers, et cetera. The clients that would be coming to ride the horses would be coming from Rut Road. We have these little connectors here. This would be more just kind of a walking path, golf cart path. We wouldn't want to have kind of any of the horse traffic, give or take, coming from the residential side. So that's how we have it laid out now. This would be an ideal situation for us to have both access points kind of separated like this.
And it currently operates a similar ag operation on another.
Correct.
And that intention would be to discontinue at that location if permitted to proceed with.
Correct.
And to be clear, the ag operation is permitted. Question that we presented to township staff, meeting with Cindy and Nate and Beth and consulting the township engineer is whether a dwelling is a permitted accessory structure to an ag operation on a farm parcel. And the conclusion was that the condition from 1996 that no dwelling shall be erected on the remaining lands. And as we discussed, the consequence of that is no dwelling of any sort prevents an accessory farm dwelling as being permitted on this property, this specific property. Yes or
Correct.
no?
Yes. Sorry.
You understand, we've discussed, and again, we've met with township staff, so we've gone through this in detail, that a dwelling as an accessory structure means that it's part of the ag operation, it's part of the farm, and cannot be conveyed as a separate dwelling on a separate lot.
Correct.
And that's not what you want in any event.
Correct.
So members of the board, our request is that the condition be modified, again, in that limited fashion, that the condition as is still regulates what it always regulated, which is the limited number of residential lots and dwellings erected on those lots, which may be subdivided from this farm historically, and that the applicants be permitted to include a dwelling house as an accessory structure to the ag operation use.
So in the 1996 decision, there were several conditions that were placed on the property. You're just trying to reverse this one, because I think one was sewage plant had to be submitted, and I think there was one other one. There's no issues with those other conditions that were
No.
attached to the decision, are
and,
there?
So, you know, the standard condition, all the other necessary approvals, comply with all the requirements related to any floodplain, install sanitary sewerage facilities, no increases in flood heights shall be permitted, comply with the testimony, et cetera, et cetera. Again, this is condition number one, and it's a piece of condition number one.
If the board would grant this request, one of the conditions I would like to see placed on the new decision, in addition to those from 1051, would be that this would have to remain a farm and can no longer be subdivided.
Unless the supervisors were to rezone this property,
Stranger things have happened.
I understand. That's what this is. I think that that is the consequence of the 96 condition. So your proposed condition would just be making that explicit.
Correct. Okay, thank you. Any questions? Oh, before you answer, anybody in the audience have any, want to be a party to this case? Sorry, Jason, forgot to ask. All right, seeing none. Gentlemen, does anybody have any conditions for the witness? Mr. Luce?
No, I don't. Obviously, you think condition.
Beth?
No.
Jason?
I don't have any, no.
Does anybody in the audience have any questions for the applicant? Mr. Cream, anything else?
Members of the board, you know, I've been practicing law in this municipality for a long time, and it occurred to me that it was in this room back in the 1980s that one of your supervisors said to me that if you want to preserve farmland, you need to preserve the farmer, and then the farmer will take care of that. I think if you were to grant this decision, that's exactly what you would be doing. Not only would you be requiring that this remain a farm property, you would be allowing that to happen.
Okay, thank you. At this time, we'll wrap up testimony in case number 2470. We will take administrative notice of case number 1051. Gentlemen, do I hear a motion? All right, I'll go ahead and make a motion. Case number 2470, the request of Eric Wardrop and Teresa Pluckett. Property located at 135 Road. Just to make sure the application is correct, let me back up here. This is a Manheim address, correct?
Correct.
So it'd be 135 Road, Manheim, Pennsylvania. I think it's
543.
17543. 17545, okay.
Yeah, 156.
Make a motion to grant their modification of condition number 1 in case number 1051 to allow for a dwelling to be put on the property of what was named in the condition as the remaining farmland. And the following conditions: number 1 are standard conditions. Number 2, existing conditions in 1051 not affected by this decision. And number 3, the property can no longer be subdivided and must stay as a farm, complete property. Do I have a second?
So moved.
Second by Mr. Bingham. Any discussion, gentlemen? If not, how do you vote, Mr. Luce?
In favor.
Mr. Kyle?
In favor.
Mr. Bingham?
In favor.
And I will also vote in favor. Your he's still off. Your request for modification of conditions has been granted.
Thank you, members of the board. Good evening.
Thanks, you too. We will take a 5-minute break before we move on to the next case.
Get around that side. Well, it would have taken an hour for me to go through what was proposing that one.
Things were, like one said, well,
Oh, on this plan?
yeah, there's one up
I gotta tell you,
near that black box, just to the
Little.
right of
the
it.
shed,
No, there's a little thing there that says something.
oh, here, I'm saying this.
uh,
Pull it up
Yeah, I
here.
just had to pull it up on our plan. I can't see.
And then down all the way at the bottom corner, there's a little
right.
box down there that isn't as directed. But it
Yeah.
looks like it has it's set a certain distance from something on the adjoining
Yeah.
property. I don't know what those.
Something existed there, right, John?
Can't read it on here.
Yeah, wondering if it was some kind of either a drain field.
Well,
or-
that could be it too, yeah.
But it comes off a property that's to the
Or it could be
right.
just an area where they, a paddock that put people on the horses. I don't know.
I don't know that it's part of their development.
Yeah.
You're talking that section right,
Bottom right.
little one.
Go right below their proposed house.
Yeah.
And there's this
Oh,
little
oh,
box.
oh, I got
with
you
a
now, I
dotted
got you.
line going.
Yeah, I
to
just
the
Got you
next
now. I got you.
neighboring
I got you. The
property.
dotted line. I thought you were talking about the black one up at top.
Well, there is that too. There's one up there by the big black box, which I guess is their horse barn.
Yes,
But there's something outside
Got it.
that too.
I'm following you.
It wasn't identified clear. I
We should
think
have
it
asked
said
what was it
well
that you
next
wanted
to
for
it.
the last
It's really
sentence?
small. But what it looked like.
They don't have all the sewers and everything there.
No, there's nothing. Yeah.
This,
Those were cans labeled worms that I
One over
decided
here.
not to open.
yes, yes, that's what you would like.
Cans labeled worms.
Or if you prefer the biological name, Lumbricus terrestris.
All right.
This one interests me. The thing that's coming up next.
It's like statement that other times it's.
I'm gathering like a whole crowd in the back row on that side is involved. In some way.
It's like another big.
all these people with you. They're all your people.
Thank you.
Thank you. How are you?
Good for yourself.
Good, thank
Mark, it's Elam, I'm back.
All right, thanks.
That's an open.
Yeah, I do. Yeah.
Hopefully, been.
Thank you.
We'll try not to hold that against you.
Thank you.
He's giving you one.
Are you ready? All right, this time we'll go back on the record. Beth, will you call the next case, please?
Case number 2471, Acadia Real Estate Holdings LLC, 3040 Industry Road, seeking a special exception.
Is there anybody in the room that wants to be a party to this case? If not, you may begin.
Good evening. My name is David Schutte. I'm a partner in the law firm of Troutman Pepper Hamilton Sanders LLP. We represent Acadia Real Estate Holdings LLC. With me this evening is Matt Rice, the hospital division president at Acadia Healthcare, and Brett Lechleiter, who's the regional vice president of the CTC division of Acadia Healthcare.
Excuse me.
Yeah.
Number one, can you speak closer to the mic? And number two, what was Brett's last name again?
Lechleiter, Lechleitner.
First name Brent. Brett.
The applicant is an affiliate of Acadia Healthcare, which is based in Franklin, Tennessee. Acadia is a leading provider of behavioral health care services in the United States. Acadia operates about 250 treatment facilities in 39 states. Acadia currently operates multiple facilities in Pennsylvania, including currently the White Deer Run facility in Lancaster, located at 53 Northwest End Avenue in the city of Lancaster. Right now, the applicant, being Acadia Real Estate, is the equitable owner of a property located at 3040 Industry Drive in the township by virtue of an agreement with J Holdings LLC, who's the current fee simple owner of the property. Property is currently improved with a commercial building measuring approximately 17,230 square feet and accessory parking and landscaping on the property. After acquisition, Acadia desires to use the building in part as an outpatient opioid treatment center and in part as an inpatient non-hospital residential treatment and rehabilitation and detoxification facility. Property is located in the Enterprise District, and the outpatient opioid treatment center use is already permitted by right as a professional, scientific, and technical office, and that determination was made by the zoning officer some months ago. The inpatient facility, as proposed, is neither permitted nor prohibited in any zoning district in the township. Accordingly, and again, this was also discussed with zoning officer and the planning director in September, and that was the determination made at that time. Accordingly, Acadia is requesting a special exception to permit the use under section 270.19 of the zoning ordinance, which permits uses that are neither specifically permitted nor denied in the zoning ordinance by special exception. As we testified to, the use is similar but distinguishable from a community rehabilitation facility, which is permitted by special exception in the enterprise district. The use that we are suggesting, the community rehabilitation facility use, which is permitted by special exception currently in your zoning ordinance, limits the number of clients to be served to 6. It contemplates a different type of living arrangement for the residents and different state licensing scheme. Nevertheless, many of the specific approval criteria for a community rehabilitation facility are very relevant to the general approval criteria that you'll find in sections 271.9 and 279.1E2 of the zoning ordinance. We handed out the exhibit booklets to the applicant's exhibits, which will identify as exhibits 1 through 6, and then there was a 7th, which is a separate document. I'll walk you through those exhibits very quickly, and we'll refer back to them during the presentation.
So before you continue.
Yeah.
You're saying that let me get my notes here. A community rehabilitation facility is not the same thing as what you're asking for?
That is correct.
What about personal care home or shelter care home?
The definition here. Personal care home is not a defined term in your zoning ordinance that I can see.
It's not a defined term in the zoning ordinance, however, based on your application and what you're asking for, either a personal care home or a shelter care home or the community home, to me, seems to fall, both of those fall under what you're asking for.
And those terms are not defined in your ordinance, so I would not know what they are. And secondly, this was the determination by the zoning officer and by the planning director that this use was not otherwise permitted in the township. So we're justifiably relying upon the staff's determinations.
Okay, go ahead.
So exhibit 1 in the exhibit booklet is a portion of the county tax map showing the location of the property. Exhibit 2 is the vesting deed into J Holdings LLC.
Let me interrupt you again. I'm sorry.
Sure.
This property is currently owned by J Holdings LLC, correct?
Correct, yes.
Unless I missed it, I didn't see any letter from them giving you permission to be here. To ask for.
Under the Pennsylvania Municipalities Planning Code, a landowner may submit an application to the zoning hearing board. A landowner is defined as one with an equitable interest in the property.
Jason, does that apply with you?
Yeah, I mean, yeah, they're an equitable owner if they have an agreement of sale that's conditioned upon them getting approval.
Okay, go ahead. Sorry.
Exhibit 4 is the proposed floor plan of the building. Should it be and that's also what's on the screen here. Should it be used as the proposed use. Exhibit 5 is a short PowerPoint deck with information about Acadia's existing facility in the city of Lancaster and its proposed use of this property. Exhibit 6 is the license issued to White Deer Run of Lancaster by the Pennsylvania Department of Drug and Alcohol Programs, which is also referred to as DDAP. And Exhibit 7, which is the extra sheet, is an aerial of the property and surroundings with a 1,000-foot radius circle. Unless there are more questions for me before we begin, I'd like to call our first witness, which is Matthew Rice.
Before you begin.
Yeah.
If the board grants this, special exception request, you will have a license issued for this particular facility, correct?
Absolutely, yeah. And that's, Mr. Rice will testify.
And as a condition, you'll be willing to accept that a copy of that certificate must be given to the township?
Oh, yeah,
Okay.
absolutely.
Thank you.
Okay, Mr. Rice has already been sworn. Would you like to give your name and business address, please?
It's Matt Rice. I'm division president and I have a home office. It's 4401 Scarlet Rose Court, Louisville, Kentucky. 40299.
And what is your position with Acadia Healthcare?
I am the division president. I'm over 11 residential facilities in the state of Pennsylvania, White Deer Run, Bowling Green, Brandywine, right out in Kennett Square, Pennsylvania. And then we also have Bradford, which is in Millerton, Pennsylvania, by pretty north, close to Williamsport.
And are you authorized to speak on behalf of Acadia Real Estate Holdings LLC and Acadia Healthcare this evening?
Yes, I am.
Okay, and were the factual statements that I made during the introductory portion of this presentation true?
Correct.
Would you please describe the inpatient program that Acadia intends to run within the building?
We currently have White Deer Run of Lancaster, which is in a residential area, which has 27 male patients. And we currently are moving to this facility, which will be a 50-bed male and female, 10 female, 40 male bed facility with an outpatient.
And what types of clients are served at the facility?
Drug and alcohol addicted clients, individuals that, are struggling, whether it be legal, whether it be employment, health, numerous issues at this point that they need some type of maybe long-term treatment, 28-day treatment.
And how are clients referred to one of your facilities?
There's marketing. We have business development reps, which go out to community mental health centers. They go to emergency rooms. We also do some drug court referrals. We do have some court ordered that are associated with some type of drug related charges. And then a lot of it is, it can be employers, EAPs, numerous, even the, police, ambulance, numerous community organizations.
Okay, and what types of treatment and care are being provided at the facilities?
Well, we're a non-hospital based drug and alcohol program. So we have detox, which is 24-hour nursing care that usually is a 7 to 8 patient wing. And then we also have residential, which is 2 levels of care. One of them is just rehabilitation, which is someone that is purely focused on the rehabilitation from drug and alcohol. And then we also have something called dual diagnosis, which is licensed by the Department of Human Services, which is an individual that has primary drug and alcohol issues, but might have some underlying psychiatric issues. The psychiatric issues cannot be acute, meaning they cannot be suicidal, homicidal, psychotic. It's more individuals with like some depression, some anxiety. They might have some disorders such as bipolar or mood disorders.
And once a client is admitted into the inpatient program, you said it's a 28-day program, do they leave the property at any time during that 28-day period?
The only time they would leave is possibly if a client's been there a couple of weeks, 3 weeks. Do we do some outside AA meetings or NA meetings, which we transport the client? We have 24-hour staff there, nurses and behavioral health associates. Plus we have therapists and counselors there during the day and evening.
So once a client's admitted, they wouldn't leave to like go to work and come back to stay there. It's not like a group
No.
home.
No, that's, that's a group home or a halfway house. Halfway house, sorry.
And, what would be the hours of operation on the inpatient side? There'd be people there 24 hours a day, correct?
Yes, it'd be 24 hours. During the day, we'd have nursing, administration, some ancillary services. We do have a full cafeteria staff, housekeeping, some security, and then behavioral health associates and counselors.
And what are the hours of operation on the outpatient side?
It's usually 5 a.m. to around 11 a.m.
And, what licenses are required to operate this facility?
We have a lot of governing bodies associated with our license, but the main one is Department of Drug and Alcohol Programs. They'll come in and license the number of beds you're going to have, the number of detox beds you'll have. And then besides them, we also are governed by the Lancaster Single County Authority. They help fund indigent care, so they have a governing body over us. Plus, we have managed care organizations also have it. Department of Human Services does our dual diagnosis program, so they also come in. Plus, we're nationally accredited by an organization called CARF. You might be familiar with Joint Commission. CARF is another regulatory or government agency that's federal.
And would this facility be replacing the existing facility in the city of Lancaster?
Yes, the existing facility is 27 beds. It is on a residential. We currently do not have a cafeteria or anything like that, so we're really looking at that process. Plus, offering female care, which has been a big push for the county because there is no female beds within the county for residential.
And are there other reasons why you want to move out of that space?
Yes, probably about a year ago, we found out that we have a parking lot right next to the facility. And we found out that they are going to be building condominiums on that. And currently, the landlord of the parking lot has let the clients use, for green space, basketball, do some recreational pieces, and with the condominiums coming, that's not an option anymore. So when we really looked at this whole process and met with the county, that's kind of what we were all looking for, is to be able to take females, but also be able to have some green space for the individuals.
And talk about the security measures that will be taken at the facility, should you use it for the inpatient care?
We have 24-hour individuals there, 24-hour, plus we have security cameras throughout. We also have a security guard in the evening if needed. And that's just really based on the environment at that point. I'm trying to think of anything else we have. And the facilities usually have alarms on the doors, especially that type, to let us know if somebody is trying to leave or anything like that.
On the screen over there is a floor plan. Can you just maybe walk us through the floor plan real quickly on how intake would work and whether there's
as you can see on the left side is the outpatient program. You can see some of the offices associated with that. And then in the middle is the inpatient where they would come in, they would be assessed. And also that's where we do a lot of our, we check individuals, make sure, health wise, nurses do an assessment. And then after they're admitted, they would go to probably more likely be dedicated to a certain bedroom, and they'd be taken there and then do an orientation toward the program.
How would food service work at the facility?
We would have cafeteria staff. Clients do not make the meals. We have cafeteria staff. They'll serve and prepare the food.
And would everybody would then eat in that living room, dining room area in the center of the building?
Yes.
And I think you mentioned earlier, a client typically stays for 28 days.
Usually a detox is, 5 days. Sometimes the managed care organizations don't, really want to certify 5 days. So I'm gonna say 3 to 5 days, and then the rehabilitation would be right after the detox phase. Some people do come in straight from rehab because we get a lot of referrals from other detox agencies that med-surg that might do a detox on a med-surg floor, and then they'll transfer them over to a rehab level of care.
And is there a discharge procedure, before, your clients are then, back out of the, facility?
You know, DDAP requires us to start discharge planning upon admission. So we are starting the process upon admission, and then prior to them leaving, we have set them up with some type of outpatient level of care or a halfway house, group home if they do not have any type of living arrangements at this point. You know, the big thing from the state agencies is to make sure that they have a proper follow-up, and, you know, we're just not putting them out on the street at this point. So all of our clients are sent to some place that they're going to continue with their care and continue with the road to recovery.
Okay, now, am I correct that, the intent is to do, no, expansions of the building, or the exterior of the building will generally remain the same,
Yes, the exterior would be totally the same.
and no additional improvements on the property?
No, just clean up. It's a little rough right now.
And, parking based upon the zoning ordinance, a building of this size, for this type of use would need, 35 parking spaces, one per 500 square feet. To your knowledge, is there enough, room in that parking field to have 35 straight parking spaces?
Yes, and I believe there's a lot more than that.
Do you anticipate any signage?
We'll just have a front sign that just says, you know, White Deer Run of Lancaster, just to let people know that's, you know, where we're at.
And, are there any regulations, in the state regulatory, field on exterior lighting or fencing or anything like that?
We'll have lighting, you know, throughout the whole building on the outside. That's part of the process, just for security aspects.
Okay, as I mentioned earlier, the proposed use differs from what the zoning ordinance refers to as a community rehabilitation facility, which I believe is similar to what the state refers to as a drug and alcohol rehabilitation home. Recovery house, that's correct. Can you describe the difference between that type of recovery house and group home type situation and the inpatient program that you're proposing?
Inpatient programs are always going to be a lot more intense programs. You know, recovery house is more, it's very similar to a halfway house where individuals are getting therapy still, but there's no nursing. You know, they're pretty much can go to work. It's very similar to a halfway house. And a lot of the homes are now, you know, partial homes are doing that too. So this, you know, they're not going to be able to go to work. I mean, they're in the program 24/7, you know, 6 to 8 hours of therapy a day, very intense programming.
And I noted earlier that the zoning ordinance also limits the community rehabilitation facility, the group home type living facility, to 6 clients. Would it be feasible to do this type of facility and only serve 6 clients?
No, it's not financially feasible.
Do you have any facilities that are that small?
No, we do have, you know, we are have the largest facility in the state of Pennsylvania, which is I think 335 beds in Allentown, Pennsylvania. We also have one in Williamsburg, Pennsylvania, which is 285.
Okay, and what would be the approval process? When would, as mentioned earlier, about the licensing, when would DDAP be able to issue licenses for this facility?
Well, you know, first we take ownership and then we'd have to do the renovations, which is I think around $5 million renovation. So it's going to be a significant amount of time. After the renovations are done, the furniture is placed in it. Everything is set up to, you could take a patient, then DDAP will come in. Usually it's about 30 days after the application. So about 30 days after you get the CO, certificate of occupancy, to come in, and then they'll do their audit survey and see if you meet all the standards.
And as I represented on behalf of Acadia earlier, should this board grant the relief being requested, would you all of the necessary approvals from state licensing agencies and federal licensing agencies be issued?
Yes, I mean, we have to have them for even payers for the MCOs.
And you'd be willing to provide copies of those?
Absolutely.
And will the inpatient facility receive similar licensing as was issued to Deer Run of Lancaster?
Yes,
Okay, and am I correct that Exhibit 6 in the exhibit booklet is a true and correct copy of the Deer Run license from DDAP? And just to make very certain, and the facility will have 24-hour on-site supervision by professionals trained to supervise these types of clients.
yes,
And have you familiarized yourself with the surrounding properties from your observations and experience with the property so far?
yes.
Okay. Are you aware of any schools, daycare facilities, camps, parks, playgrounds, public libraries within 1,000 feet of subject property?
No, I'm not.
Okay. And Exhibit 7, which was a aerial photograph, is that an accurate depiction of the 1,000 foot radius circle?
Yes,
We've reviewed those properties, and there are no types of facilities like that within that 1,000 feet.
yes,
And will the inpatient facility be run in strict conformance with all local, state, county, and federal guidelines?
absolutely.
Has the Deer Run facility in Lancaster ever been cited or otherwise in violation of the applicable regulations or its licensing requirements?
No,
Okay. Do you know of any issues in Pennsylvania for Acadia's facilities?
no, I mean, just the standard, every once in a while documentation issues, every hospital has, but no, we haven't had any issues.
And what's your relationship with the county, the single county authority and the 5-county system?
Very, very good.
Okay. Have grants been awarded for this project?
Yes, the single county authority awarded us $300,000 to find and replace the facility we have, plus the 5-county consortium has given us a grant of 1.7 million to assist in the purchase of the property. With total that, we believe that the total investment from Acadia will be around 6.5.
And have there been discussions with both the single county authority and the 5-county system for a need for this type of facility in Lancaster County?
Yeah, the big push of them was the female population. The males, we have 27 beds, and they stay 95% occupancy. So, there's always a need for some type of increase in the bed. But all the females was the biggest issue, which they really do not have any place in the county. A lot of the individuals were going out of the county for treatment.
Okay. Are you familiar with the uses permitted in the enterprise district under the zoning ordinance?
Yes,
Okay. And do you agree that the proposed inpatient use is similar, or compatible to the proposed uses in the enterprise district?
I think it will be.
And just to go quickly here, the intent of the enterprise district is areas of the community that are prime for business enterprises due to vehicle and rail access, utilities, and infrastructure. The uses in this zone due to their size, scale, potential impacts, environmental impacts, truck traffic, rail access type of activity are appropriately located at a desirable distance from neighborhoods, schools, parks, and recreation areas. And these business areas provide essential benefits to the township, including employment, economic and financial stability that help move and create a sustainable community. Would you say that the inpatient proposed use meets that type of intent?
Yes.
Based upon your understanding of the zoning ordinance as a whole, is this partial use of the building as an inpatient facility in conflict with the general purposes or intent of the zoning ordinance?
No.
Based upon your understanding of the surrounding neighborhood, would the use of the building as the inpatient facility be detrimental to public health, safety, morals, or the welfare of the community?
Absolutely not.
Based upon your understanding of the surrounding neighborhood, would the proposed inpatient use, if allowed, substantially change the character of the surrounding neighborhood?
No,
Is the building served by public water and sewer?
I believe so.
And to your knowledge, is there adequate fire, police, and ambulance protection?
Yes.
Okay, in your history of working with these facilities in Pennsylvania and elsewhere, how often is a police, ambulance, or fire protection needed at one of these facilities?
Very rare. I mean, it would be individual that just like us, if we checked in for alcohol and, we're having medical issues and, we might collapse, then, ambulance would come. The police would only come if they're, it's like anything, any business out there, if the, police are needed. It's very rare, but they, they could come. And fire would only be the worst case scenario, I guess.
Is the vehicular access to the property adequate for the inpatient use?
Absolutely.
How are your clients typically transported to the property?
An individual, well, usually we are transporting about 80% of the population that comes into our facilities. That's one thing we offer. A lot of individuals do not have the family or the resources to be able to get their, themselves to a treatment program a lot of times. So we offer the transportation. We do not do the transportation, usually it's a family member that would drop them off. We do not allow them to have their vehicles on site. So they do not have a vehicle there at the property.
Is the location of this facility in harmony with the orderly and appropriate development of the enterprise in the district?
I believe so.
And is the nature and intensity of the operations in harmony with the orderly and appropriate development of the enterprise zoning district?
I believe so.
Okay, if this was permitted, if this use is permitted by the board, would it cause a material increase in traffic congestion?
I do not believe so.
Would it increase commercial traffic use in residential streets?
No.
Those are all the questions I have for Mr. Rice.
Any questions for Mr. Rice? Elam? All right, I'm
Not
gonna,
at this time.
I have a couple. I understand why you want to move out of a residential area. With all the zones that are in this township, going into an enterprise zone that's specifically centered on light industrial, heavy industrial, railroad businesses, that would not be my first choice. Why there? Why not a campus location?
Well, first thing is to find a campus location is very tough.
That one right down the street,
With the building,
Bill Noon.
that's a little tough too. Really what we found in the past is, I know you think industrial was, not a good spot, but it really serves a purpose because there's really nothing you can get into. I mean, I know you think there is, but these clients are right there. So we don't have, a lot of individuals driving by a lot of times, personal, it's mainly business pieces. So it really works out for us. And a lot of our facilities, not just us, I've been in the field since 1990 and I've opened numerous facilities. We like these areas. Just not a lot of foot traffic, and that's, it comes through. So it really helps us out, with monitoring and making sure that, we don't have people just trying to drive up and see what's going on and things like that.
In your opinion, why does that not, fit a, did I get this right? A community rehabilitation facility?
I think one of the things with the 6, I think that was based on probably fire regulations, federal. You can't have, 6 people under the same roof that are non-related. And I think that's why the 6 comes out on that community behavioral. But realistically, these are, I don't want to say nursing homes, but it's kind of the similar concepts. Because realistically, these individuals they're 2 to a room. A lot of times they can go up to 4, but they're 2 to a room, and it's 24-hour nursing care. We have physicians, we have psychiatrists coming in. So it's very similar to like a residential, I'm gonna say a nursing home or some type of assisted living pieces.
Okay, and I believe the state defines a personal care home. This would fall under a personal care home under the state's definition. So this makes this an allowable use, if you agree with that, in the campus location, which I just saw you shaking your head. So that would put your whole special exception request mute because it is allowed.
I know that other areas have not, it's not been a personal care home. But it's been defined for drug and alcohol residential treatment.
Again, community rehabilitation to me, falls under that. And I can't speak for the rest of the board, but to me, what you're asking for would either fall under a personal care home or a community rehabilitation home. So, if you buy into that, then this is allowable in the enterprise zone. You at that point need a variance for the 50 beds, which that's a huge variance request. And the only thing I could think of, you could reason why making that big of variance request would be economic. And the state already says that doesn't hold water in the issues of a variance.
As a legal argument, community rehabilitation facility, and I sent an email to Jason explaining this earlier today. Community rehabilitation facility, one is limited to 6, which is not within even close to the industry standard for this.
Excuse me, could you speak closer to the mic?
Certainly.
Thank you.
Being limited to 6 clients, which is a requirement for the community rehabilitation facility, is not even close to the industry standard, as Mr. Rice pointed out, for this type of facility. Secondly, it's a group living quarters, which connotates more of a group home, group living situation rather than an inpatient type facility. Keep mentioning personal care home. Again, personal care home is not a defined term within your zoning ordinance, so we really can't determine whether or not this is a personal care home or not. Instead, it is a inpatient rehabilitation facility as a non-hospital, inpatient non-hospital residential facility, as that term is defined by the state regulatory board.
And also on the community rehabilitation, they do not offer detox. I mean, we have a detox wing with 24-hour nursing and doctors, they see them. That's not going to be in a community where they live together. It's more of a living, group living piece.
Okay, thank you. Jason?
Yeah, so you mentioned that there was some sort of coordination with the township planning and zoning staff before the application. I mean, was there a request for a written interpretation or anything like that?
There was early on before there was early on in which the staff initially said that this was a community rehabilitation facility without knowing the size and intensity of the program. After that, there was a telephone conversation where we discussed with Ms. Graham and Mr. Sturgis what this precisely was, in which we received the guidance of that this is a use not otherwise permitted, and to pursue that section of the ordinance, section 1.9 of the ordinance.
Okay, but you acknowledge that in order to grant a special exception, this board has to make a finding that it is indeed a use that's not provided for, correct?
Say that this board could make that decision, or they could rely upon or we should be allowed to rely upon the staff's interpretation of the zoning ordinance in presenting the application to the board.
So other than the limit of 6 beds, would what you're proposing to do be consistent with the definition of community rehabilitation center and also the criteria?
No. Well, it's consistent with criteria except for 6 beds. It's not consistent with the definition. The definition begins with group living quarters. This is not a group living quarters. This is an inpatient treatment facility. The two are different, and the community rehabilitation facility is not a defined term in the state regulatory scheme. Rather, is most similar to the drug and alcohol recovery house, which again, this is not what we're proposing. Again, we're proposing an inpatient, non-hospital rehabilitation facility with 24-hour care.
Are you, Mr. Rice, are you familiar with the state's having some sort of personal care home? Is that a category? Is that a specific licensed use by the state that
They
you're
have
aware of?
halfway houses and recovery houses, which are both 6, and we're 6 people and they live together. There's no nursing. There is some counseling that comes in during the day. There's no nursing, and it's usually a couple groups a day. And then they go to work and things like that, which is not this. This is intense. This is 6 to 7, 8 hours a day of therapy with 24-hour nursing, with also counseling, plus doctors, psychiatrists come in.
So are you saying that is what the state licenses as a personal care home is what you described? Is that,
Well, I don't.
is that a
I guess
state designation?
Let me try to rephrase that. What is it?
Mr.
A
Shooty,
personal ca-
make sure you're speaking to the mic.
A personal care home is not defined in your ordinance.
Oh, yeah, correct. I'm
Okay.
just wondering, the question was whether it's something.
The personal care home, something that's licensed by the state in your drug and alcohol rehabilitation
No, it's
industry.
not. No, it would not be called a personal care home.
Okay, thank you.
Beth? So you may hear me, Mr. Shooty. To me, what you're describing and the state doesn't dictate to the township exactly what they have to define everything as.
Right.
The township is responsible for defining their own. Again, at this point, everything you've described to me fits in either into a personal care home / shelter home or a community rehab. Again, which are both allowable uses. There are allowable uses in this township. If this board, basically for your special exception request, this board needs to make a determination of whether to, if the use is defined in the township or not. If this board decides that the use is defined in the township, they will deny your request because it's defined in the township, which makes your special exception request moot. If this board finds that it is not defined in one of the zones in the township, then they could approve your variance request. Or your special exception request, sorry. So how do you convince us that this is not does not fit into one of those two categories?
I think we've provided quite a bit of testimony and evidence and logic. First of all, as the community rehabilitation facility, as Mr. Rice testified, the definition here being a group living quarters, which this is not. A group living quarters is similar to a group home, which is also defined in your ordinance, which is a supportive living arrangement that does not have 24-hour care. We're talking about 24-hour care. We're talking about that the clients do not leave the area. It's not like a living, it's not like they're group living and community living. That's like they're cooking their meals together in the kitchen. This is a 24-hour inpatient care facility. in his industry, no such facility has 6 or less clients to it, which again puts it way outside of this zoning ordinance's definition of community rehabilitation facility, which means it's not permitted as this facility, which means it needs to be, it's something else.
So what falls within 50 beds, 75 beds, 100 beds? Where do you make that determination? Where do you make that cutoff at?
Well, that cutoff would be made based upon the state licensing, the size of the building, the size of the property, the available staff.
There's a requirement per square footage for each individual.
But looking at it from a township perspective, where do you cut that off at? Do we write the ordinance to allow for a 50-bed home? Do we allow up to 75-bed homes? That's what I'm saying. Where does the township fit into this to make that cutoff?
I think it'd be similar to sizes of houses, sizes of warehouses, sizes of any facility, number of apartments permitted. It is limited by the land, limited by the size of the building, limited by parking, limited by all of the other dimensional and other performance criteria that sits with every other use.
Okay. Any other questions? Yeah. Mr. Herr, any questions?
No, just following your argument there and the attorney's argument back to you. So if a building somewhere in the township, a large building, becomes available, if I understand the applicant's attorney, the applicant could theoretically put 300 beds in that building, then would be an acceptable use, no matter what the ordinance may say.
I would say, provided that it meets all of the other performance standards and the state licensing standards, which seems to be the most important criteria for approval in this ordinance.
Okay. Anybody in the audience have any questions of Mr. Rice? If not, you may call your next witness.
Wait, before you do that, one other question, just did you say what uses in the district that this is similar and compatible with?
Or we cannot. Other than the basic intent of being away from residential facilities, I'd say it's not compatible with the professional, scientific, and technical offices, compatible with municipal uses, compatible with
Excuse me again, could you get closer to the mic? I'm having a hard time.
and compatible with,
Thank you.
although not the same as community rehabilitation facilities, and compatible with correctional facilities, all of which are permitted by right or by conditional use within the enterprise zone. And I also note that it's not compatible with residential, as Mr. Rice was pointing out, and residential uses are not permitted at all within the enterprise zone.
Thank you.
Can I ask you a slightly different question? Who determines when one of your residents is prepared to go out and function in a normal society? That is, can a person sign themselves out of your facility, or must they go through a process to get out?
They can sign themselves out, but we work to keep them engaged in the program. So, whenever they decide, whenever the counselors decide that it's time, they've completed what they need to, and we're going to move on, then the physician and the counselors will write a discharge summary, and they'll go ahead and discharge the client to the appropriate level of care.
But you're saying a client could do it on their own if
Yeah, they could.
they were of age, or I'm not sure what your criteria would be. But
We do not
it
take
is a
anyone.
difficulty with this type of facility if someone can just say, I don't want to be in here anymore.
Yeah, you know, we do not deal with psychiatric, suicide, homicide, psychotic individuals. So this is someone that if they are in our facility, they could have, some drug and alcohol related charges. But usually, if they're leaving, usually we're transporting them wherever they're going to. So, because that's one thing we do offer. We offer the transportation home.
Follow up on that, Matt, if somebody would choose to discharge themselves contrary to their treatment plan or medical advice, would they be able to come back with, and how would that affect them personally?
Well, I mean, they're definitely not ready to probably be out. They're going to leave early, I would say. But, we would assess them again if they need, care down the road to see if they, are a little more motivated, want to stay engaged in the program. Let me stress, White Deer Run of Lancaster has been 25 years. We've not had issues. Our license is in good standing. We are in a residential, and when I say residential, we are connected buildings to houses. So, and we have very little green space and we do not have issues. So, I want to stress, these are people, most of these people are very engaged in their programming. They want to get help. Some of them are swayed not to, and they want to leave, but few and far in between. There's more people that's going to be motivated to stay in the program.
That's fair.
Mr. Hanson, Beth just found that the term personal care home is actually defined. It's defined under dwelling unit terms and phrases. So if you look at, it's in my book, it's page 12 of 150. But it's under dwelling unit terms and phrases, personal care home / shelter care home. So it says personal care homes provide safe, humane, comfortable, and supportive residential settings for adults who do not require the services in or of a licensed long-term care facility, but who do require assistance or supervision with activities of daily living or instrumental activities of daily living or both. Residents who live in personal care homes receive the encouragement and assistance they need to develop and maintain maximum independence and self-determination.
Based upon that definition, would you say that the proposed use is embraced by that definition?
Absolutely not.
So, excuse me, so you're saying that you don't try and develop in your patients a need to maintain maximum independence and self-determination?
Yes, we would.
So obviously fits the
But prior to
definition.
that, they're gonna, they have, even though these are not acute psychiatric, these are acute chemical dependency. When they come in, their bodies coming from the drugs and alcohol are gonna have withdrawal symptoms. And if they're on any type of benzodiazepine or alcohol, they could have life-threatening if they're on the right medication. You cannot do that in a personal care home or a, what's the other one? Community.
Any other questions for the witness? Call you next, please.
We have no further witnesses. Just I'd like to summarize that again. The discussions with the township staff gave us the guidance that this is a use not otherwise provided in the ordinance. We relied upon that guidance, and as we demonstrated this evening, the proposed use is not otherwise permitted. It is not a personal care home. It is not providing a safe, humane, although it would provide a safe, humane, comfortable, supportive. It's not a residential setting. This is an inpatient, non-hospital facility. And in a personal care home, it does not require the services of a licensed long-term care facility. Here, this is a licensed facility that is required. Personal care homes are licensed completely differently than the facility that we're speaking of this evening also. Also, as we mentioned earlier, community rehabilitation facility, this is not a group living quarters. This is not communal living among folks that are struggling together as one would typically see in a recovery house. This is an inpatient facility that is not otherwise provided for in your ordinance. Past that threshold question, all of the elements of a special exception under both section 1.9 and 9.1 have been testified to in the affirmative by Mr. Rice. So we ask that this board grant the relief being requested and grant a special exception to allow this use at the subject property.
Okay, with that, we will end testimony on case 2471. We will take into administrative notice applicants exhibits 1 through 7. Exhibit 1 being the tax parcel, exhibit 2, the property deed, exhibit 3, purchase and sale agreement, exhibit 4, proposed floor plan, exhibit 5, program details, exhibit 6, signature of licensure, and exhibit number 7, the overhead view from Google Maps with showing the 1,000-foot radius around the proposed building. Gentlemen, I will entertain a motion at this time.
Mr. Chairman.
Yes, sir.
There was a lot brought up in this testimony. I suggest that we take the 45 days allowable under the MPC to render a decision.
Gentlemen, we have a motion. Do we have a second?
Second.
We have a motion and a second. Any discussion? If not, how do you vote? Mr. Luce?
In favor.
Mr. Kyle?
In favor.
Mr. Bingham?
In favor.
Mr. Herr?
In favor.
I will also vote in favor of taking the allowable 45 days. There will be a December meeting.
Just a question. May I present a written memorandum of law on the issue to assist the board?
Why don't you send it to the township and they'll make sure we get a copy of it before we make a decision.
Okay.
Okay.
How quickly would you need that?
Oh, not this week, trust me. Next week will be fine.
On Thursday, please send it to us.
Next week will be fine.
Okay, great. Thank you.
You have to excuse Mr. Luce. The Eagles are playing and he's getting a little frustrated. So if you can just get that to us next week.
Great, thank you.
Beth, I know we have one case and we'll have a decision for this one. Is that it?
That's it, yeah.
Cheryl, you're available? Gentlemen, you're all available, which would be December.
24th.
No, you're not that lucky.
Not the 25th?
December 18th. Everybody available?
Mr. Chairman, I'm not sure if I'll be available or not.
Okay, well, we have at least 3 available, so we'll be good. And you said you're available. Jason, you're available. You're good?
Yes, sir.
Okay. In that case, let's adjourn this meeting, go watch some football.
Thanks, gentlemen.
Hey, Elam,
Yeah.
Andrew was gonna make the 45-day motion, so